I want to give you a live look now. The hearing has actually resumed, so we're going to hold off on that panel and take you there live to the House Judiciary.
Watchdog and hold government agencies as important as the Department of Justice and FBI accountable. And I just want you to know how much we appreciate your work and your team's work. Likewise, I think it's important, even though we're critical of the leadership of the FBI during the last administration and the way they mishandled this counterintelligence investigation, I think the rank and file agents in the FBI and their colleagues in the intelligence community need to know that we are there for them and support them in the faithful discharge of their responsibilities. I happen to have the privilege of serving on the Intelligence Committee and the Judiciary Committee, and I like to think that there is no more ardent supporter of our law enforcement agencies or our intelligence community than I am. And I believe that General Hayden, when he wrote his book about his experience at the CIA, had it right. It was called Playing to the Edge. Playing to the edge of your authorities, not over the line, but up to the edge in the interest of our national security. But I think that also makes it important for us to root out illegality, mendacity, deception in the exercise of the authorities that are given to our intelligence community. And so let me ask you a little bit about that. Because I can't think of anything more damaging to the intelligence community, the FBI and the DOJ, than what you have uncovered in this 400-page report and what we've seen here. It really is very troubling. Can I ask you, the Foreign Intelligence Surveillance Court, as you have pointed out, considers the application of a foreign intelligence surveillance for a warrant by the FBI, working with the National Security Division at the Department of Justice. Do you believe if the court knew what you know now, that it would have ever issued the Fisa warrant in the first place?
You know, we're careful not to predict what federal judges would do, presented with the evidence, and whether there would be sufficient basis to find probable cause. I know that they would not sign a warrant if they were told not all relevant information was included in it.
Yeah, or if they were lied to.
And certainly if they were lied to.
And do you know whether the court is currently considering this matter?
Well, I know the court, based on discussions with folks at NSD, at the National Security Division, that they have the report and that they have a follow-on letter from the department about this matter.
Well, I hope they will not let this pass, because if this misbehavior, this illegality, this deception becomes a routine, I agree with Senator Graham that it will be the end of the authorities that Congress has granted under the Foreign Intelligence Surveillance Act, which I think would be very damaging to our national security. The Foreign Intelligence Surveillance Act includes the word surveillance, obviously, and you can't surveil an American citizen for intelligence purposes except under very specialized and exacting circumstances. Would you agree with that?
That's correct.
Because the rights given to an American citizen under the U.S. Constitution are laid out in the Bill of Rights, among other places, and there is a higher standard with regard to getting a warrant, let's say, to wiretap or to investigate an American citizen than there would be a foreign agent, correct?
That's correct. There's particularly sensitive circumstances around surveilling a U.S. person.
So the whole exception here, which authorized the court authorized the surveillance of Mr. Page, was based on some proof or some indication, some suspicion he was an agent of a foreign power, correct?
Correct. They had to show probable cause to believe he was an agent of a foreign power.
But as you pointed out, they got incomplete and misleading information in that process. Agreed?
The court got inaccurate, incomplete information. Agreed.
So what's the difference between surveillance and spying?
Well, surveillance, and the term I'm going to use and we use in the report, is what's in the law, the Foreign Intelligence Surveillance Act.
You don't like the vernacular?
I'm going to stick to what we do as IGs, which is look at the law and stick to what the language is in the law.
Well, to my mind, there's really no difference. although it's legally authorized according to the Foreign Intelligence Surveillance Act, it's an active covert intelligence gathering against here a foreign power or an agent of a foreign power. Let me ask you about the defensive briefing.
Yep.
And you've explained in response to Senator Graham's questions the difference between a counterintelligence investigation and a criminal investigation. And I believe at some point during the last few years, I remember Loretta Lynch, the former Attorney General, say that defensive briefings were routine in counterintelligence investigations. Would you agree with that?
You know, I frankly don't have enough experience with them on the national security side to tell you one way or the other.
You don't have.
I've heard that be said, but I don't know specifically.
You don't have any reason to disagree with?
No reason to disagree.
Okay. So if they are routine, if Attorney General Lynch is correct, the decision by Mr. Priestap, the head of the counterintelligence division of the FBI, not to provide an extensive counterintelligence briefing, defensive briefing to candidate Trump and his campaign would be unusual.
If it's usual, then not doing it, yes, I agree, would be unusual.
What was even more unusual is the fact that when the Director of National Intelligence went to provide what turned out to be a perfunctory briefing to the Trump campaign, lasted about 13 minutes, I think you indicated in your report, that they had implanted into that group an agent, FBI agent that was part of the investigative team for a crossfire hurricane. Is that correct?
That's correct. The agent, there was one FBI agent there, and they chose the agent from the counterintelligence investigation.
So instead of their mission being to provide candidate Trump and his campaign to arm them with information so that they could prevent the Russians from infiltrating their campaign, this briefing, such as it was, had a dual purpose. The agent, it says on page 342 of your report, actually prepared himself going through mock briefings headed by Stroke, Lisa Page, the Intel section chief, and possibly the general counsel unit chief, correct?
That's correct.
So this was not just an incidental sort of thing. Obviously, there were plans made for the agent to go in as part of this defensive briefing and perhaps get General Flynn to inadvertently offer information that might be helpful to the FBI in their investigation.
Yeah, and as explained to us, it was dual purpose. One, to see if anything was said during the briefing in response to the briefing that would be useful for crossfire hurricane purposes immediately, but also, as the agents told us, for purposes of a future interview of Mr. Flynn, which did in fact occur later.
And so Mr. Flynn was clearly the target.
He was certainly, of the three people there from the Trump campaign, the only one of the three who was a subject of an FBI investigation at the time.
And he wasn't told that he was under investigation or that the agent was there hoping to bait him into providing incriminatory information, or and the agent didn't provide him any declaration or admonishment of his Miranda rights, correct?
He certainly wasn't told there was a dual purpose to the briefing.
Well, it looks to me like Director Wray was so concerned about this that he's, as you pointed out, said that this will never happen again.
That's right.
Is that what you said?
That's correct.
So let me ask you, Mr. Horowitz, are you familiar with the fact that Director Comey had a meeting with President Trump in January of 2017 to talk to him about the Steele dossier?
I am, and we actually referenced that in our report about his preparation and handling of the memos that came out of that meeting.
Why should we believe that Director Comey's so-called defensive briefing, if you want to call it that, of the president in January 2017 was anything more than an attempt to try to bait the president into providing incriminatory information which would be useful to the FBI in its counterintelligence investigation or potentially some future criminal investigation?
I have no information one way or the other to make a judgment on that, but as mentioned earlier, one of the concerns with doing that here is that it leaves open the possibility that people might ask, did it happen elsewhere?
Well, it strikes me as fraught with danger, just like it was for General Flynn, for the director to go into the White House, the Oval Office in the White House, not to tell the president that anything he says could be used against him in an ongoing investigation, potentially including criminal charges. And the final thing I would say is I agree with the chairman. If this is going to happen to a presidential candidate or the president of the United States, what kind of protection do average American citizens have that their government won't array this vast power against them and essentially ruin their lives? To me, that's a profound concern as a result of your investigation.
Thanks, Mr. Chairman. And picking up on that editorial comment, I've been joining Senator Leahy and Senator Lee for years talking about this FISA court. Yep. And we now have an ample record here in this case and in a lot of others. 2002, the FISA court identified more than 75 cases in which it was misled by the FBI. Internal FBI review in 2006, dozens of inaccuracies provided to the FISA court. The list goes on and on. So let's have a fulsome conversation after this about the future of the FISA court and the representations that are made to it. Let me try, if I can, Mr. Horowitz, thank you and your team for being here, to go through a few points. The chairman gave an uncharacteristic, flowery, heated opening that went on for some 40 minutes and produced a lengthy record of emails from Lisa Page and Peter Strzok, which repeatedly demonstrated statements of hostility toward candidate Donald Trump. He went on to say these were the people in charge. When I read your summary of your findings, you didn't find either of them to be in charge, did you?
On this investigation, we did not.
Okay. When it comes to expletives, you also, on page 339 of your report, found some agents at the FBI who had an exactly opposite political viewpoint. Correct. And were very positive toward candidate Trump and very open in their use of expletives to demonstrate that.
Yeah. And those individuals, to be clear, were not part of the Crossfire Hurricane team, but were in a different field office interacting with the Crossfire Hurricane team.
And I hope we can all concede the point. We don't believe anyone in this capacity, this delicate capacity with life-changing decision-making every single day should be so politically biased as to call into question their values and their character.
That's correct, and I made this point last year when this issue came up. Individuals at the Justice Department and the FBI are allowed to have their political views. They're allowed to be voters. They're allowed to be engaged citizens. They should be. They can't, though, tie their personal views to their investigative acts.
And I'm sure that's one of the things you've shared with Director Wray.
Correct.
All right. Also, the chairman made a point early on of talking about the fact that the Trump campaign was not notified of this ongoing investigation until a much later date after it had been initiated. And I would just say, be careful what you wish for, because there are those of us who look at the James Comey October 28th public declaration about the Hillary Clinton investigation as being deadly in terms of the outcome of this election. So this notion of the FBI publicizing investigations, making them known to many people, can cut both ways. It's good to know, I'm sure, but you run the risk that as more people come to know it, it becomes public knowledge. Is that an issue?
Yeah, look, we wrote the last year's report about that concern of what Director Comey did in that regard, and you obviously want to control information and make sure only the people who actually need to know it.
So the point I'm trying to get to is the chairman's opening suggested a bias, at least in this instance, that the FBI and others, against Donald Trump that he believes was manifest in many of the things that followed. I could argue from our side of the table, we can find bias that includes Comey's statements, public statements right before the election that really had, in many of our points of view, determinative outcome. Let me go back to the irrepressible, ever-present Rudolph Giuliani, because here's something. During the 2016 campaign, Rudy Giuliani, who was then a Trump campaign surrogate, bragged about having access to information about the investigation of Hillary Clinton's emails. Right. He teased in October 2016 that a surprise was coming. And on November 4th, after Director Comey sent his letter reopening the investigation, Giuliani said, and I quote, "I had expected this. Did I hear about it? You're darn right I heard about it," the mayor said. So How can we be dealing with those kinds of statements that long ago and still not have some resolution as to whether or not he was just bluffing or, in fact, he had moles in that New York office? If I remember right, one of Comey's rationales for his public announcement was, I couldn't do it through the New York office because it leaks like a sieve. Is there no investigation, or has there been no investigation of this?
So, as I mentioned last year when we released our report on the Clinton email investigation, we are looking at still that question. And the challenge of that investigation, as I mentioned back then, I'll mention again, is proving who spoke to whom and when based on records at the FBI, and understanding that there's rarely going to be substantive information we will get, for example, from toll records or others, but we will find out context, and we're trying to follow up. We're continuing to do that. We've issued 2 reports so far about findings we had of leaks and misconduct, and we have investigations ongoing.
Mr. Giuliani now professes to be President Trump's lawyer, and occasionally the president acknowledges that. Sometimes he doesn't. Are there any concerns that Mr. Giuliani may be continuing to improperly obtain information from sources in law enforcement not authorized to provide it?
I'm not going to sort of speak to what we've learned or what we know about what our ongoing investigations, and I'm not investigating matters related to the ongoing Ukraine issues that I think you're referencing.
Let me ask, if I can, on this question of the problems within this case, particularly as they relate to the treatment of individuals who were engaged in it. And I'm thinking particularly of the ongoing questions about whether or not one particular individual was treated fairly here. Is it your conclusion that he was not Ms. Page was not a Russian agent? Or I should say, did not have important contacts that were not in the best interests of the United States with the Russian leadership? I'm
not in a position to assess that. What I can assess is looking at the evidence that the FBI put forward to the Fisa court. A significant number of pieces of that evidence do not support their theory of the case. And that was never told to Justice Department lawyers, who are the ones who are the gatekeepers and have to be able to know that information to make that decision. They're the experts, not me.
Could we speak for a moment to the Steele dossier, Steele
Yes.
file in this case? I believe you had a pretty definitive statement about what impact that Steele file had on the initiation of this investigation. What was your conclusion?
In terms of the initiation of the investigation, it had no impact.
No impact.
No impact. It was not known to the team that opened the investigation at the time they opened it.
So you've concluded in several different ways that there's no evidence of political influence for the opening of this Crossfire Hurricane investigation. Is that correct?
Correct.
All right. Let's see if there's anything else here. On this FISA reform issue, I can get back to that later, but one thing that's interesting here, and Senator Lee is not with us at this moment, he's introduced a bill which I'm co-sponsoring, which would give the Inspector General's office, in this circumstance, the authority to investigate attorneys.
Correct.
In the department. Right now, that's not allowed under the law, is it?
That's correct. It is not. And thank you for co-sponsoring the bill, as have several other members of the committee.
It seems to me to be obvious. Why should, do you know what the theory is behind their being separate and not subject to this investigation?
This is a legacy of history. Back in 1988, when the IG was created at Justice, the compromise was that attorneys would be carved out. By the way, so was the FBI and DEA at the time, and that we would have jurisdiction over everybody else. After the Aldrich Ames spy scandal, Attorney General Ashcroft actually changed that and gave us the authority over DEA and FBI. Congress codified it in 2002, but attorneys still a carve-out. We're the only IG that can't review conduct of all the employees in our organization, including attorneys.
And Attorney General Ashcroft was authorized to give you that kind of option?
Under the statute as it then existed,
As it existed.
he had the authority to do that. The statutory change took that away.
Mr. Chairman, I hope you'll consider that when we're putting together an agenda. Thank you for your service.
Thank you. And I will go to, I think, Senator Sass, but just 30 seconds here. Has anybody been charged with working with the Russians, illegally working with the Russians that were part of the Trump campaign that you know of?
Not that I know of.
Okay. Senator Lee.
Thank you very much, Mr. Chairman. I find the conclusion that some have raised that your report, Mr. Horowitz, somehow exonerates the FBI in this matter to be crazy. Absolutely crazy. To the point that it almost makes me wonder whether those who are making this argument have read the same report that we're talking about today. Perhaps they're talking about a different report. There is no planet on which I think this report indicates that things were okay within the FBI in connection with this investigation. They most certainly were not. And yet, stunningly, former FBI Director Jim Comey took to the pages of the Washington Post to declare that this report, your report, shows that, quote, the FBI fulfilled its mission protecting the American people and upholding the U.S. Constitution. I don't understand that. I find it absolutely stunning that he would reach that conclusion. This is nonsense. I don't care where you fit on the political spectrum. If you are a politician or if you are a non-politician, if you are a liberal or a conservative, a Republican, a Democrat, regardless of your age, your views, you should be deeply concerned about what's in your report, Mr. Horowitz. This report is a scathing indictment of the FBI, of the agents that were involved, and I want to be clear about that because the FBI is an institution that has a long history of respect in this country. And as a federal prosecutor, I worked with the FBI. I found many of its agents to be people of utmost integrity and thoroughness. And that's part of why I'm so concerned by your report and its findings, the facts stated therein. It's because I think this really damages that. There is a lot of good in this country that comes not just from the FBI being good, but also being understood to be good. The behavior outlined in your report is, at a minimum, so negligent. I actually would say so reckless that it calls into question the legitimacy of the entire Fisa program. And I don't say that lightly. I say this, of course, as someone who has long questioned the Fisa program and how it could be abused, but this really pushes us over the edge. I'll get back to that in a minute. The report concludes, way too generously in my view, that the report, quote, did not find documentary or testimonial evidence of intentional misconduct on the part of the case agents who were involved in investigating the Trump campaign. But the report goes on to call the conduct of the agents and the supervisors involved to be, quote, serious performance failures, which you noted were failures for which you did not receive a satisfactory explanation. Is that right?
That's correct.
Serious performance failures. Failures without any type of satisfactory explanation. This is the failure that Jim Comey astoundingly, stunningly, irresponsibly considers a fulfilled mission, a mission that includes, among other things, protecting the constitutional rights of the American people? I think not. This is what the former head of the FBI considers protecting the American people and upholding the Constitution. I just can't understand it. It's simply not good enough. It may be good enough for Mr. Comey. It's not good enough for the American people. Every American really should be terrified by this report. The FBI team that investigated the Trump campaign was, as has been pointed out, handpicked. After all, it couldn't and wouldn't and wasn't the case that they would just pick any ordinary investigators to investigate a presidential campaign. especially the presidential campaign of one of the two major party nominees, for what was acknowledged in the report to have been one of the most sensitive FBI investigations. These agents were supposed to have been the best of the best, and we wouldn't expect anything less in that circumstance. They were supposed to be of the highest character and professionalism, committed to protecting the civil liberties of all Americans. You see, our privacy is not at odds with our security. Our privacy is inextricably intertwined with, and indeed, an inseparable part of our security. We cannot be secure unless our privacy is also guaranteed. We certainly can't be secure in our Republican form of government if, after all, our Republican form of government is imperiled by people who choose to politicize the intelligence gathering and law enforcement apparatus that our federal government has. So we're faced with two possibilities. Either one, these FBI agents purposely used the power of the federal government to wage a political war against a presidential candidate they despised, or two, these agents were so incompetent that they allowed a paid foreign political operative to weaponize the Fisa program into a spying operation on a rival presidential political campaign. I'm not sure about you, but I'm not sure which one is worse. I am sure that neither conclusion is acceptable. They're both horrifying for slightly different reasons. I'm not sure there is a substantive distinction between the two of them. I'm not sure one can conclude. I'm not sure it's possible to conclude that the bias evident in communications between some of these investigators wasn't at least a part of it. Now, the fact that you say that there wasn't a causal connection between them, that there wasn't a sine qua non with but-for causal chain between those communications and the opening of the investigation itself is beside the point. The fact is, these were agents who made their bias clear, and they went after someone in part because they did not like his candidacy, and that's inexcusable. The report in the FBI's abuse, I believe it's longstanding abuse, I believe it's inevitable abuse of Fisa and the Fisa court to surveil American citizens, should, in a sense, not be of tremendous surprise to us. James Madison warned us against this very kind of thing in Federalist 51 when he said if men were angels, they wouldn't need a government. If we had access to angels to govern us, we wouldn't need rules about government. But alas, we are not angels. We don't have access to angels to govern us. And so we have to have auxiliary precautions. We have to have checks and balances to make sure that no one person or no one entity gets too much power. And added to those checks and balances, we also have substantive limitations, like the Fourth Amendment. We have things that are there to protect us. I've believed for some time, as has been noted earlier in this hearing, and I've teamed up with people at the opposite end of the political ideological spectrum, that Fisa carries with it an unacceptable risk of abuse. That's why I've teamed up with Senator Pat Leahy over the last 9 years that I've served in the Senate and on the Senate Judiciary Committee, because I believe these programs are subject to abuse. I've been warning for years that inevitably these would result in abuse. It's not a question of if, but it's when and how soon will government officials get caught doing it. It actually surprises me in some ways that it took us this long to find an instance where you get caught. But then again, that is what happens. When you take a standard that is malleable, that requires virtually no public accountability, you render all but a small handful of Intelligence Committee lawmakers in the House and in the Senate, you render all other citizens other than them and other than the intel community itself ineligible to review their work. And then you make it possible for them to gather information. This kind of thing is, of course, going to happen. It's never not going to happen. And that scares me to death. Now, Inspector General Horowitz, you've stated several times today, both in your opening statement and in response to questions, that you did not find documentary testimonial evidence of bias that influenced the FBI's decision to conduct these operations. But Mr. Horowitz, is not the lack of evidence that you're talking about itself evidence of bias? Isn't the lack of evidence on bias evidence that we really should take as bias? But it's, in any event, it's certainly not itself indicative that no bias occurred. Isn't that correct?
As to the opening, which is in a different place than the Fisa issues that you've identified and I talked about earlier, I think it's two very different situations. On the Fisa side, we found, as you noted, a lack of documentary testimony evidence about intentionality, but we also noted the lack of satisfactory explanations and, in fact, leave open the possibility that, for the reasons you indicated, it's unclear what the motivations were. On the one hand, gross incompetence, negligence. On the other hand, intentionality, and where in between, we weren't in a position to, with the evidence we had, to make that conclusion.
My point
I'm
is,
not ruling it out.
your lack of evidence here is not evidence that there was no bias.
I'm solely basing it, correct, on the actual evidence that we have.
Thank you very much.
But, Mr. Horowitz, you actually did make a finding on that very question, did you not? I direct you to page 14 of the executive summary, where you ascribe this to management and supervisory failures that were not specific to this case, but that were potentially endemic. Is that not correct?
I'm sorry, on the Fisa side?
Yep, you say that so many basic and fundamental errors
Yes.
were made by three separate hand-picked teams on one of the most sensitive FBI investigations, raises significant questions regarding the FBI chain of command's management and supervision of the FISA process. You then go on to describe it as a failure of managers and supervisors.
Right.
And you go on to say that your remedy is an OIG audit, not only of this case, but of other cases that have nothing to do with the Trump campaign, nothing to do with politics. So you actually do make a finding about this, and that is that you attribute the failure here to a failure of management and supervision that could well go beyond this particular case.
Correct, although not just managers and supervisors, obviously. All the line people who had responsibility, the prosecutors, they made very serious errors.
But you make no finding that this was attributable to a deep state conspiracy or a political conspiracy or any such type of motivation.
We make no finding. We explain in there that we did not have documentary or testimonial evidence that it was intentional. We also point out the lack of satisfactory explanations. And from there, I can't draw any further conclusions.
Correct. Other than you do, what you go with is that there was a failure of management and supervision over this complicated process that needs to be repaired.
From top to bottom.
Correct. Now, when did the what's the timeline on the Attorney General getting notice of this report? How long did it take between when he first saw this and when he credited this? He said that your investigation is a credit to the Department of Justice.
Well, we first provided the draft report for classification marking purposes right at the beginning of September, end of August, beginning of September.
So he and his team have had it for over a month, well over a month.
Yeah, and then we got it back from them with the markings. We did the normal process in a classified review. We then incorporated the markings, then produced it back in November for the factual accuracy.
And the director of the FBI would have
Same
had
thing.
access to it during that time frame?
Same exact time frame.
Same exact time frame. And he complimented you on its thoroughness and professionalism and says that he accepts the report's findings, correct? With plenty of time to review it.
Correct.
Now, then we get to Mr. Durham. Did Mr. Durham have access to this report during that same period of time?
No, we did not give it to him in the end of August and September, precisely because it was for classification purposes. He had no reason to see it.
Yep.
We were very careful as to who could see it and who couldn't.
Yep.
We had the department keep lists of who could see it and who couldn't see it to control it.
He was not on the list?
He was not on the list. We provided to him in November.
Yep.
As part of our factual accuracy review.
November when, do you remember?
I could check, but it was probably roughly mid-November.
So are you familiar with what he is undertaking at all?
I'm somewhat, but not, I wouldn't pretend to be completely familiar with it.
He notes that he does not agree with some of your report's conclusions as to predication and how the FBI case was opened. What information do you think he has access to that you did not have access to?
I have no idea.
When you look at Director Wray's letter, he says that his organization, the FBI, provided broad and timely access to all information requested by the OIG, including highly classified and sensitive material. And he accepts that the Crossfire Hurricane investigation was done for an authorized purpose and with adequate factual predication. I'm trying to figure out where the world of evidence exists about predication that you didn't have access to and that FBIA Director Wray would not have access to. Where could John Durham be going for information that is outside of the scope of what you have access to or what FBI Director Wray has access to?
I don't know, and you'd have to ask the Attorney General or Mr. Durham.
I mean, hypothetically, is there some area of evidence that you're aware of that you didn't get access to?
We are not. We got 1 million records. We asked the FBI for all of the materials in their possession, including from other agencies.
Does he have a grand jury operating, do you know?
I have no idea, and I couldn't say if I knew.
Is he going overseas to debrief foreign agents and interests?
I have no idea. You'd have to talk with him.
Okay. Predication involves a threshold, does it not?
Correct. For opening an investigation.
Yeah. And when you've hit your predication threshold, more evidence doesn't, as long as the evidence is adequate, more evidence doesn't take it away, correct?
Correct.
So I'm also trying to figure out how it is that even if he had more evidence that you did not have, that takes away from your conclusion that predication was adequate.
Again, I think you'd have to ask him or the Attorney General.
You can't think of a way to get there, can you?
I don't know. As I said earlier, we stand by our findings.
So you describe serious performance failures in the FISA process. Those are likely to lead to either disciplinary actions or to sanctions by the court, or at least be considered for those things, correct?
Those are certainly two of the options, yes.
Yes. And in that process, those individuals will have a chance to defend themselves. There's due process involved.
Right. We are not the adjudicators. That goes to the department, the court, or any other entities that might.
So we may find out more as those processes go forward in that context.
Correct, you might.
Okay. Now let's look at the intelligence briefing. At the time of that intelligence briefing, what did the FBI know about how far Russian interests had penetrated into the Trump campaign?
I don't know, as I sit here, the level and extent of the FBI's knowledge. We were looking at the origins of the Crossfire Hurricane investigation in these 4 cases.
But the FBI clearly knew that there was an investigation going on because it was their investigation.
Yes, and we lay out here some of what they knew. I just can't sit here and tell you other than
Carter Page, correct?
I'm sorry?
They knew the concerns about
Correct.
Carter Page, and he was associated with the Trump campaign.
Correct.
They knew they had an investigation going on into Michael Flynn at the time.
Correct.
Do you know if they knew about the Trump Tower meeting 2 months before the intelligence briefing with the
I don't
Russian
know.
agents?
I don't know one way or the other.
Okay. And going into it, it would be reasonable, wouldn't it, to expect that the FBI did not then know how far Russian penetration into the Trump campaign went?
I have no idea at what stage their investigation was at that point in time. I have no reason to doubt what you're saying, but I don't know independently.
So there was no way that they could rule out that people present at the intelligence briefing on behalf of the Trump campaign might have actually been involved in the Russian operation.
I have no knowledge of that. All I know as to that is they had the open investigation on Mr. Flynn.
Yeah. So they certainly couldn't rule out when he was actually in that briefing that
As
he
I
was a
said,
potential participant in
Right.
the matter that they were looking into.
yeah, and as I said, Senator, Crossfire Hurricane was bigger than just the pieces we were looking at, so
Yep.
I can't sit here and tell you what else the FBI may or may not have known at the time.
So while we can agree that putting Operation Crossfire Hurricane agent into the intelligence briefing of the Trump campaign might have been over-aggressive. For the FBI to be in that intelligence briefing would be perfectly appropriate, correct?
In fact, absolutely appropriate for them to be there. That was the debate that went on internally at the FBI, which is what to do, and they never, which they did not discuss either with anyone at the department, the appropriateness of it, or at ODNI. It was the DNI's.
But there was no reason the FBI shouldn't have been in that briefing.
The FBI should have been at that briefing
Precisely.
for intelligence purposes.
For intelligence purposes.
To give an intelligence briefing.
And it also would have been perfectly appropriate for a Crossfire Hurricane agent to have debriefed the FBI agent present at the intelligence briefing to see if Michael Flynn had said anything relevant to the investigation, or anybody else for that matter. It was information potentially relevant to the investigation, was it not?
Depending what occurred there, you could foresee a hypothetical where that occurred. I think it raises serious policy questions that, frankly, the FBI director needs to sort through and understand with leadership at the department, because that briefing and those briefings are for purposes of protecting campaigns and to allow transitions to occur.
And it was an unusual circumstance.
And
a participant in that briefing on the part of the Trump campaign was the subject of an FBI investigation.
That is correct, but it raises significant policy questions.
But we should not draw the conclusion that there's no way the FBI should ever be given access to evidence that arises in the context of an intelligence briefing related to counterintelligence.
And that'll be up to Director Wray in responding to our recommendation to sort through that policy
question. Time has expired, and thank you.
Thank you. Senator Cruz, if I had just 30 seconds here. In the January meeting with the primary subsource, the Russian guy who provided Steele with all the information, wasn't there a Department of Justice official present at that meeting?
Yes, let me clarify on that. The people present were the primary subsource, his lawyer, 2 FBI Crossfire Hurricane people, and for parts of the interview, lawyers from the National Security Division. They were there not knowing the background necessarily. They were there because the primary subsource had a lawyer.
Okay.
And so the FBI wanted a lawyer there in case there were lawyer issues.
So we're beating up on the FBI, I think appropriately so to some point, but the Department of Justice, they were in the room too.
They were in the room, but the reason we note this here is there's a number of instances here where people get drive-bys.
No, I got you.
Right, and in government, you get a drive-by and someone tries to tag you with something that's not fair. That was our concern.
Fair enough. Senator Cruz.
Mr. Chairman, can I just close one point from page 341? The FBI's Mr. Baker told the IG and is quoted in his report as saying that the agent in that investigative briefing, quote, was not there to induce anybody to say anything. He was not there to do an undercover operation or elicit some type of statement or testimony.
Thank you.
Make sure that's in the record.
Very good.
Thank you.
Senator Cruz.
Thank you, Mr. Chairman. Mr. Horowitz, thank you for being here. And I want to start by taking the opportunity to thank not only you, but the men and women of your team that are gathered here. I think the work that you've done in the Inspector General's office is incredibly important. Reading this report, this is a 434-page report that lays out what I consider to be a stunning indictment of the FBI and the Department of Justice, of a pattern of abuse of power. And I will say both the Department of Justice and FBI for decades have had a great many honorable, principled professionals with a fidelity to rule of law. And this indictment, I'm an alumnus of the Department of Justice. This pattern of facts makes me angry, and it makes anyone who expects law enforcement to be nonpartisan and faithful to the law, it should make them angry as well. Now, the press has focused on your specific conclusion that you did not find evidence of political bias. That's a judgment you have. I disagree with that judgment. But I think that judgment is in many ways the least significant component of this report. I think the facts that are in this report need to be understood, and they should be deeply chilling to anyone who understands the facts in this report, and then people can draw the inference as to why that pattern of abuse occurred.
Do you agree with that?
I'm sorry.
Do you agree with what he just said?
I think everybody can, the purpose of this report is to lay out the facts for the public, and everybody can debate and decide what they think of this information. I absolutely agree.
So this 434-page report outlines 17 major errors and misstatements that were made by the FBI or DOJ in securing FISA warrants. A number of them are deeply, deeply troubling. These are not typos. These are not small, inadvertent errors. These are grotesque abuse of power. Let's focus on a couple of them. The primary subsource. Primary subsource, and indeed the first error you note in the second, third, and fourth application for the FISA warrant is that the primary subsource reporting raised serious questions about the accuracy of the Steele dossier, which we now know was a bunch of malarkey, to use a term that's been in the news lately, and that the FISA court was not informed of that. Now let's get specifically, so the basis of this Steele report was what's referred to in your report as the primary subsource. That was the principal basis. And the FBI interviewed that primary subsource not once, not twice, but 3 times in January, March, and May of 2017. So that's the basis of this dossier. What did the primary subsource say? As the OIG report says, the interviews with the primary subsource raised, quote, significant questions about the reliability of the Steele reporting. What did the subsource say specifically? As your report goes on to say, it says Steele misstated or exaggerated multiple sections of the reporting. It says that portions of it, particularly the more salacious and sexual portions, were based on, quote, rumor and speculation. It says that some of the basis of that came from conversations with, quote, friends over beers and statements that were made in, quote, jest. And the primary subsource also says to take the other subsources, quote, with a grain of salt. Now, the FBI had that information, knew that the basis of this dossier was saying it's unreliable. And what did the FBI and DOJ do? In renewal application number 2 and number 3, the FBI advised the court, quote, the FBI found the Russian-based subsource to be truthful and cooperative with 0 revisions. You note that as the most significant misstatement, and that is going in front of a court of law, relying on facts that you know are unreliable without any basis. That was the number one. Yep. The number 2 major error in the applications was omitting Carter Page's prior relationship. Now, we now have evidence that Carter Page functioned as a source for a United States intelligence agency. That's a pretty darn important fact. If you're telling the FISA court, hey, the fact that this guy Carter Page, who I don't know this guy Carter Page, but the fact that he's talking to Russians, really suspicious. Well, the fact that he's serving as a source for U.S. intelligence agents is pretty darn relevant to why he's talking to Russians, because we have lots of sources that are talking to bad guys. And when you don't tell the court that, you're deceiving the court. But it's worse than just deceiving the court. Because, as the OIG report details, an assistant general counsel in the FBI altered an email, fabricated evidence, and reading from the OIG report, specifically the words, and not a source, had been inserted into the email. That email then was sent on to the officials responsible for making the decision to go forward. And as the report said, let me read on page 256 of the OIG report, the final paragraph. consistent with the Inspector General Act of 1978 and following OIG's discovery that the OGC attorney had altered the email that he sent to the supervising agent, who thereafter relied on it to swear out the final FISA application. So the men and women at home need to know what's happening. A lawyer at the FBI creates fraudulent evidence, alters an email, that is in turn used as the basis for a sworn statement to the court that the court relies on. Am I stating that accurately?
That's correct. That is what occurred.
Now, you have worked in law enforcement a long time. Is the pattern of a Department of Justice employee altering evidence and submitting fraudulent evidence that ultimately gets submitted to a court, is that commonplace? Is that typical?
I have not seen an alteration of an email end up impacting a court document like this.
In any ordinary circumstance, if a private citizen did this, fabricated evidence, and by the way, what he inserted was not just slightly wrong, it was 180 degrees opposite what the evidence said. So the intelligence agency said this guy is a source, and he inserted this guy is not a source. If a private citizen did that in any law enforcement investigation, if they fabricated evidence and reversed what it said, in your experience, would that private citizen be prosecuted for fabricating evidence, be prosecuted for obstruction of justice, be prosecuted for perjury?
They certainly would be considered for that if there was an intentional effort to deceive the court. On this one, I'm going to defer because, as we noted here in the sentence you indicated, we referred that over to the Attorney General and the FBI Director for handling.
Third major omission that the Department of Justice and the FBI did not tell the court is that this entire operation was funded by the DNC, was funded by the Hillary Clinton campaign and by Democrats. It was an Oppo research dump. Look, at some level, this is the most effective Oppo research dump in history because the Department of Justice and FBI were perfectly happy to be hatchet men for this Oppo research dump. Now, throughout every one of the filings, DOJ and the FBI didn't inform the FISA court that this was being paid for by the DNC and the Hillary Clinton campaign. Is that right?
That's not in any of the FISA applications.
So they didn't tell the court that. And it's not like DOJ didn't know. Indeed, one of the senior Department of Justice officials, Bruce Orr, his wife worked at Fusion GPS, the Oppo research company being paid by the DNC. And he became the principal liaison with Steele without telling anyone at the Department of Justice that he was essentially working on behalf of the Clinton campaign. Who at the Department of Justice was, and by the way, several Democrats, it's interesting seeing Democratic senators wanting to defend this abuse of power. Several senators, Senator Feinstein said, and I wrote this down, the FBI didn't place spies in the Trump campaign. Senator Leahy said something similar. Well, that may be true, not spies in the Trump campaign, but reading from your report, in particular page 4 of the executive summary, your report says, thereafter, the Crossfire Hurricane team used the intrusive techniques, including confidential human sources, to interact and consensually record multiple conversations with Page and Papadopoulos, both before and after they were working for the Trump campaign, as well as on one occasion with a high-level Trump campaign official who was not the subject of the investigation. So they didn't place spies in the campaign, but they sent spies to record senior members of the campaign in the middle of a presidential campaign when that candidate was the nominee for the other major party that was the opposing party to the one in power. Is that right?
They send confidential human sources in to do those.
Did anyone at DOJ, who at DOJ knew about this? Did the Attorney General know about this? Did the White House know about this?
Based on what we found, nobody had been told in advance.
But once
Nobody
it was happening,
knew about
did they know?
They did not. The only evidence that somebody knew were the line attorneys in NSD, in the National Security Division, when they were told very selective portions of what had occurred. Nobody knew beforehand. Nobody had been briefed. And frankly, that was one of the most concerning things here, is that nobody needed to be told.
And I can tell you from my time at the Department of Justice and from my time in law enforcement, any responsible leader, when hearing that you're talking about sending in spies and sending in a wiretap on any presidential nominee, should say, what in the hell are we doing? And by the way, the people up the chain who are saying we didn't know, if you had responsible leadership, there's no more important decision than you make. I can tell you when I was at DOJ, if someone said, let's tap Hillary Clinton, or let's tap Bill Clinton or John Kerry, the people there would have said, what in the hell are you talking about? What was going on here? This wasn't Jason Bourne. This was Beavis and Butthead.
Senator Klobuchar.
All right. I want to tone things down a little bit here. And first want to express my gratitude for the thousands of men and women who work every day on the front line with the FBI. I come from a background as a prosecutor, and our local law enforcement work with the FBI every day in our local office in Minnesota. And then in the Senate, I've had the privilege to work with many, many people in the FBI. And I think the Inspector General's job is incredibly important. He keeps everyone honest. But I do think it's important for those agents and for those in law enforcement that are watching today that people understand there are people up here that understand that you're simply doing your jobs, which I think is basically, with some suggestions and recommendations for change, what the Inspector General found in this report. So before I start my questions, I think it's important to put this discussion in context with what happened in the 2016 election, which is why we are here today. It is now undisputed by our intelligence agencies that Russia invaded our democracy, not with bombs or jets or tanks, but with a sophisticated cyber mission to undermine the underpinnings of our very democracy, a democracy that hundreds of thousands of men and women have lost their lives on the battlefield defending both our democracy and democracies abroad, a democracy that 4 little girls' innocents at the height of the civil rights movement lost their lives in a church in Birmingham, Alabama, because people were trying to hold on to that democracy and make sure that it was extended to people in this country. So let's remember why we're here today. Let's remember the words of Dan Coates, the former director of the National Intelligence Agency, who served in the Senate, well respected by colleagues on both sides of the aisle. He said that, in fact, Russia has been emboldened to do this again. And I did appreciate Senator Graham's words that he made clear that it was not Ukraine that invaded this election. It was Russia. And it was the words of Fiona Hill and the impeachment hearings over in the House that I thought were important to remember. She said anyone that is repeating this lie is basically peddling in Russian propaganda. So let's remember that this is not about one election or one party. It is about our democracy. What can we do? Well, we can be honest, and we can stop making political hay out of this, and we can actually take some actions that would protect our election in 2020. And that includes finishing the work that Senator Langford and I have started to pass not only the money, which I appreciate, to help states to secure our elections, but to also get in place requirements to push those states that don't have backup paper ballots fully, 11 of them, to get those backup paper ballots, and to make sure we have audits and to make sure we have better communication between federal and state authorities, to do something about the propaganda by actually moving forward on the bill that Senator McCain and I had and that Senator Graham and I now have, the Honest Ads Act, which requires those social media companies, and I have absolutely no idea why we don't do that, to play by the same rules of the road for paid political ads, which would greatly help us, but not completely, but greatly help us with this propaganda problem. So here we go. You wrote this report, Inspector Horowitz, after interviewing more than 100 witnesses and reviewing over 1 million documents. Is that right?
That's correct.
And under department guidelines, an investigation has an authorized purpose if it is open to detect, obtain information about, or prevent or protect against federal crimes or threats to the national security, or to collect foreign intelligence. You found that the investigation at issue today was open to determine whether people associated with the Trump campaign were coordinating with the Russian government. Is that right?
That is the reason the FBI provided.
And again, to be clear, you did not find that the FBI acted improperly when it opened the counterintelligence investigation that you reviewed in writing in this report.
That's
Is that
correct.
right? The department's guidelines also require that a decision to open investigation is supported by, as you describe in your report, allegations, reports, facts, or circumstances that indicate the possibility of criminal activity or a national security threat. You found that the FBI's investigation was predicated on a report from a friendly foreign government that heard that the Trump campaign had received some kind of suggestion that Russia could help them by releasing information that was damaging to Hillary Clinton. Is that right?
That's correct.
As a former prosecutor, I know that it is critical that the FBI is able to take an action like it did here to investigate threats to our national security. Do you think that interference in our elections by a foreign government constitutes a national security threat?
Yes, I do.
Okay. Does anything in your report call into question the finding in the special counsel's report that the Russian government interfered in the 2016 presidential election in a sweeping and systematic fashion?
No, it doesn't. In fact, we cite the special counsel's report here in a footnote laying out all the different reports that have been released on that issue.
Does anything in your report call into question Chairman Burr's statement, the Republican Chairman Burr's statement, that, quote, Russia is waging an information warfare campaign against the U.S. that didn't start and didn't end with the 2016 election?
No, it doesn't.
Does anything in your report call into question the assessment by FBI Director Wray that Russians' interference in our elections is ongoing and that its interference in the 2018 midterms were a, quote, dress rehearsal, end quote, for the 2020 elections?
No, it doesn't.
Does anything in your report call into question the finding in the special counsel's report that, quote, the Russian government perceived it would benefit from a Trump presidency and work to secure that outcome?
We don't take issue with any part of the special counsel's report, no.
Okay. Did you find any evidence that political bias or other improper consideration affected the FBI's decision to open the investigation into George Papadopoulos?
No, we don't.
Did you find any evidence that political bias or other improper considerations affected the decision to open the investigation into Paul Manafort?
No, we don't.
Did you find any evidence that political bias or other improper considerations affected the decision to open the investigation into Michael Flynn?
We did not.
Did you find any investigation that political bias or other improper considerations affected the decision to open the investigation into Carter Page?
No documentary or testimonial evidence or other evidence.
So we are clear, did your report uncover systematic political bias at the FBI?
As to what we looked at and the openings, we did not find documentary testimonial evidence to support a finding of bias.
Can you comment on why it is critical that the American people have confidence in the rule of law and the independence of the Justice Department?
Absolutely. I also was a former prosecutor and federal prosecutor previously. I did public corruption cases in Southern District of New York. And the whole foundation of the Justice Department and law enforcement on the federal level and at the state and local level is apolitical, non-political decision-making made by prosecutors and agents working together to protect communities.
Very good. I want to follow up on your discussion on the issue you briefly discussed, whistleblowers, with Senator Feinstein, because it's so important, and I know that Senator Grassley also cares a lot about this issue. Can you speak generally to how often in your career information provided to whistleblowers has proved important and led to uncover wrongdoing?
Well, I'll speak to certainly my experience in the 7 years as IG, as in the first instance. from the get-go, fast and furious, critical that the agents came forward there. We've found numerous instances in our audits and our reviews with whistleblowers coming forward and reporting evidence. And I'll add, going back 30 years to my career as a prosecutor in New York doing police corruption cases, we had a incredibly brave and courageous police officer who saw corruption in his midst and came forward and reported it, and allowed us to make a very substantial police corruption case that would have continued but for that courageous officer.
Thank you very much. That's really helpful. After your report was released on Monday, Attorney General Barr stated his opinion that the FBI launched an intrusive investigation of a U.S. presidential campaign on the thinnest of suspicions. When the FBI decided to open its investigations, the U.S. Intelligence Committee was already aware of Russian efforts to interfere with the 2016 election. Is that correct?
I'm actually not sure what the Intelligence Committee knew at the time.
It was in that context that the FBI received information. I'm just going to let's move forward, understand your answer. That the FBI received information from a foreign government, which we know from reports came from an Australian diplomat, that reported that a Trump campaign official suggested that the Trump campaign had received some kind of suggestion from Russia that would assist the campaign by releasing information that would be damaging to Hillary Clinton's campaign. Is that correct?
That's correct.
Your report also quoted then Chief of the National Security Division, David Loffman, who said that it would have been a, quote, dereliction of duty and responsibility of the highest order not to commit the appropriate resources as urgently as possible to run these facts to the ground and find out what's going on. Is that correct?
That's correct.
In light of all of that was occurring at that time, and it's always easy in hindsight to look back at things, but at that time, do you agree with Attorney General Barr that the investigation was predicated on the thinnest of suspicions?
Well, I'm not going to get into a comparison on what his view. He's free to have his opinion. We have our finding, and as I said earlier, I stand by our conclusion.
And your conclusion, again, is?
That it was sufficient predication to open the investigation based on the low threshold required by department and FBI policy.
Thank you very much.